like that's a controversial song right there, winning by Mr. P. And I mean, he has gone a long way in trying to prove that that song is originally his. Let's move ahead to other stories. Now we have a guest in the house who's going to be joining us to talk about copyright infringement. He's a legal practitioner with specialized focus on entertainment law, intellectual property law, regulatory compliance. He serves an array of incredible talents such as Perry Jackson. We have Vulcan Monix, Cupid Season, Inyoluwa Gems. He has Teddy Crane and Neza as well. He's also the convener of the Creative Mastery Forum. Personally, I'm pleased to have this person on set with me today, virtually, William Umoh. Good afternoon, William Umoh. Can you hear me? Williams, can you hear me?
Yes, I can hear you. Can you hear me?
Very well. Good afternoon. Welcome. How are you doing?
Good afternoon. I'm okay. Thank you for having me.
Well, I'm so pleased to have you on the show this afternoon. We'll talk about a little bit concerning copyright infringement and, of course, Rude Boy and Mr. P's situation. Starting off with how do you even get yourself? Now, we've seen in the situation of Peter and Paul right here how you can get to be accused or charged with copyright infringement. But aside from something like this, let's talk about lay people, like lay artists who haven't gotten to this kind of recognition. What kind of action can you take that will cause you or that will cause you to be charged with copyright infringement?
All right. Thank you for that. So, copyright infringement first stems from the copyright law. And under the copyright law, there are several works that are eligible for copyright protection. So, you have the musical works, you have the sound recording, you have literary works, you have artistic works, you have broadcast, right? In this particular instance, since we're dealing with music,
Yeah.
it falls particularly under musical works and sound recording, right? So
Okay.
musical works is the composition bits of a song, while the sound recording is actually the process of, let me use layman term, burning it on a CD or putting it in an MP3 format where it is now being ready for commercial release, right? So
Okay.
that is the sound recording bit of it. Now, to be guilty of copyright infringement, Section 36 of the Copyright Act clearly provides for the several instances. I think there are about seven of them. But the notable amongst them is when you do an act or cause a person to do an act, right,
Yeah.
that infringes on the exclusive rights that the Copyright Act provides for authors. Now, the question then is, what are these exclusive rights? So remember, I told you that there are about five range of works that are eligible for copyright protection. Now, for these five ranges of works, right, you
Okay.
have certain exclusive rights that the copyright law grants to the authors or owners of the work, as the case may be. Now, number one, you have the right to reproduce the song, right? You have
Okay.
the right to publish, you have the right to perform the song, right? You have the right now, in the case of sound recording or maybe musical composition works that are intended to be used in a movie, right? Sync
Yeah.
licensing is what is being referred to as. Now, in those cases, also, the author or owner of the work has the exclusive right to license such works or use such works for however purpose or whatever purpose he or she deems fit, right? So
Okay.
these are the exclusive rights. Now, anyone who does any act or causes another person to carry out any act that tends to malign any of the exclusive rights granted by the Copyright Act is said to be infringing on the copyright of another. Now, there are other instances, such as in situations where you import a work from a foreign country that is ordinarily meant to be protected under copyright in the Nigerian law. There are also instances where you get to sell, right? For instance, there's the popular, I think everybody should know, Alaba Market. Now,
Yeah.
those era when, or in the era when we had CDs, where people would just carry CDs, burn songs that belongs to several
Another
people,
person.
and then start selling it or distributing, right?
Yeah.
That is also an instance of copyright infringement. So
Okay.
doing any of the acts listed under the seven instances given in Section 36 of the Copyright Act will warrant or will be an infringement of the copyright that belongs to a person.
Okay, so in order to use this person's song, this artist's song, for whatever reason, example, movies, because I see that in some movies, they make an original song for the movie, while in others, they get to either reproduce the person's song to sound like something that fits into their movies, or even to some extent use a particular artist song for that movie. Do they have to reach out to the artist, or is that also infringing on the original artist or work?
Okay, so in an instance where they fail to obtain license for that, that
Okay.
will be an infringement, right? So,
Yeah.
like I mentioned, under literary works, artistic works, and musical works, right? You cannot align it to an audiovisual work. Now, movies, so to say, are referred to as audiovisual works.
Okay.
So, before you can make use of a literary work, an artistic work, or a musical work, right? In a movie, which is an audiovisual work, you have to seek consent from the owner or author of the work,
Okay.
right? So that is referred to as synchronization license. So the process where you are syncing a particular song or a particular line from the song, let's say maybe you decide to use a particular 15 seconds line or 20 seconds, however you decide in a song, the implication is that you're having to use the copyright belonging to another person. So the proper thing to do is to reach out to get a synchronization license, which then gives you the right to make use of that person's work, right? Now,
Okay.
failing to do so means that you've infringed on the right of that person, and of course, the person can take an action against you for copyright infringement.
Okay, so in cases where there are
So,
no,
so, so,
okay,
okay, yeah, go ahead.
in cases where no direct evidence, like for example, the recording of the song being available, people knowing that this is yours, maybe the evidences you have are evidences of, let me say, very, just the rough work of it or something, and somebody still uses your song. For example, this entire Mr. P and Rude Boy. Let's say that Rude Boy actually just did a rough work while he was in the studio. What is it's originally is his intellectual property, and someone uses it and releases the song. We also had the case of Omale saying that he gave someone an idea and the person immediately carried it to do his own Afrobeat album and he couldn't release his. When you don't have a direct evidence, what else can be used as an evidence in cases where this person is going to be charged to court for copyright infringement? What evidence can be used in cases like this?
Okay, so first of all, what must be clarified is the fact that Section 4 of the Act, alongside, I think, but let me just start from Section 4, and I think Section 67 sub 4 thereabouts, provides that, Section 4 particularly provides that there are no formalities required for a work to be eligible for copyright, right?
Okay.
And then I think 64 sub 7 then provides that it uses the word may, right? And then it then makes it such that registration of the work is prima facie evidence. That is to say, by virtue of Section 4, you do not necessarily need to register a work before you own the copyright to that work,
Okay.
right? So let me give an instance in the Mr. P and
Wood
Rude Boy
boy.
saga, right? So let's say Rude Boy actually got a pen and paper and then just started writing down the particular lyrics to that song, right? Automatically, what he has written down on that paper enjoys copyright protection. So he necessarily doesn't need to register it before it can be said that he has the copyright to what he has written down. Now, in
Okay.
the case of Omale, he said he had an idea where he shared with someone. Now, copyright doesn't protect ideas, or intellectual property generally, intellectual property laws doesn't protect ideas. Now, for copyright, the criteria is that the work must be in a fixed state. First of all, it must be original. That's to say, you must have expended energy and time in trying to create an original work. Then, secondly, it must be in a fixed state such that it can be perceived, or it can
Okay.
be communicated, or it can
Okay.
be felt, whatever the case is, right? So this will then mean that the moment you put down an idea that is in your head on a piece of paper, immediately you start writing it down and you complete it, that work enjoys copyright protection,
Okay.
right? Immediately you have an idea of a song, you get into the studio and you start voicing it out, it enjoys copyright protection. But then it is also advisable to take an extra step of registering the work. Because by the time you're now going to be arguing with the person that, oh, I'm the first person, because of course what copyright protects is the first person who actually did the work, right?
Okay.
That is
We had
what
the idea.
that's what copyright law. Yes. So if you are unable to show that you are the first person that brought that work to life or brought that idea to life, then it's very likely that the protection won't suffice in your case. Now,
Okay.
for a person who has taken the step to then register, so the certificate of notification from copyright now serves as evidence to show that you are actually, it's called the first in time principle. So you are actually the first person who brought the work to life. Hence, the copyright protection covers you and protects your work in that instance. But your inability to show that you're actually the first to have brought that work to life will mean that the law doesn't avail. So you could then, now, like I said, it's prima facie evidence. So except you have any other evidence to dispute that this person wasn't the first person to bring out this work. And let's not even forget, as an addendum, is the fact that a work infringes on the copyright of another doesn't mean that that work is not eligible for copyright. Section 2 sub 4 of the Copyright Act provides that the single fact that a work infringes on the copyright of another doesn't mean that the work won't be eligible for copyright. So it means that you can still go ahead and register, or a work that you have done that infringes on the right of another can still enjoy copyright protection. So it's then left for you to be able to prove that you are actually the first person who brought this work to life before it can then be said that you actually own the copyright to the work.
Okay, so I think you've really gone far to explain that in a layman term. I'm sure every artist or creative at all will be able to understand that. But let's move away from that to in a situation where the original owner of this, intellectual property is dead. Now, what happens to the royalties that come to this person, who is obviously dead? What happens to the royalties? Are they transferred to the next of kin, or how does it actually work?
Okay, so for that, I will bring two instances to play, the instance of Fela and the instance of Michael Jackson, because those are
Prominent
the two
people.
the two notable legends that are deceased, but you still have their works being exploited and bringing in tons of money,
Yeah.
billions, if not billions of money. So what happens is that the act, I think. Coming to the Nigerian context. Now, under the Act provides for the moral right of an author. Now, the moral right means that you have the right to determine how your work is being used and for what purpose the work is being used for, right? So
Yeah.
it states that that particular right is not transferable. Now, upon the death of the author or the owner of the work,
Yeah.
it can then be transferred, right? To, of course, going by testamentary, that is if the person has a will, or going by the laws. But ordinarily, right, just making it as simple as possible, ordinarily, where a person dies, the copyright ownership of that work will then be vested in the estate of the deceased, right? But
Okay.
let me also put in context that copyright has a duration through which a lifespan of a copyright exists or subsists, right? And so you have some are 70 years after the death of the author, right? While
Yes.
you have some being 50 years after the death of the author. Now, for musical works and I think sound recording, they are essentially covered under the particular section that says that 50 years, so the copyright will last for the duration of the author's life and 50 years after the
After.
death of the author. So after that 50 years, then it's deemed that the copyright ownership no longer exists. So it then reverts to public domain, and then anyone can then
Use it.
maybe do the work or whatever it is to then claim ownership. So it means that even when so why I'm saying this is because even when the rights has now been vested in the estate of the deceased, 50 years after the death of such author or owner of the work, then the
Okay.
copyright ceases to exist.
All right. Thank you so much, William Umoh. But just before I let you go for like 30 seconds, tell me what is your thought on this entire Mr. P and Rude Boy controversy over the song "Winning" that just got released?
So for the controversy, I mean, you have one party coming to show you proof that, oh, he brought the producer, he's making calls with the producer, showing receipts of the fact that, oh, we flew the producer in to be able to produce the music aspect of the song. So it's a case of being able to prove. Now, if the case is going to go to court, but before it even gets to court, there are other remedies that are available to a person or an author or owner who feels that his work has been infringed upon. So you can simply issue a takedown notice if you can prove
Okay.
that that work actually belongs to
Belongs
you.
to
So you
him.
issue a takedown notice to the streaming platform, and then they take down the song pending when the issues are being resolved.
All
But
right.
then if the case has to go to court, then the person has to prove, of course,
Mr. P.
offenses, copyright offenses essentially fall under criminal liability, right?
Okay.
So you'd have to prove beyond reasonable doubt.
Doubt.
That's the implication. They're offenses. So they have to be proved beyond reasonable doubt that, oh, you actually have ownership or you were the first person who brought that work to life. So where Rude Boy is able to prove that his work was actually the first, either by virtue of notification of the Nigerian Copyright Commission or through whatever means he wants to use to show that his work was the first in time,
Yeah.
then is likely to succeed. But where he is unable to prove that, and of course, even with the streaming platforms, where it is taken down, and then Mr. P is able to prove that the work is actually or originally his,
His
then the song will still be re-uploaded on the platform and
platforms.
everything returns to normal. So it's
All right.
basically a case of who is able to prove what.
All right, thank you so much, Williams. That's where we wrap it up on the show this afternoon on Entertainment Noun. I hope that for future creatives and people in the entertainment industry, we've been able to learn in one way or another how copyright infringement comes to play and what you're meant to do, the rules you should follow when you are trying to recreate someone's property. My name is always Vera Phillip, and it was really amazing to be here with you. Till tomorrow, where we'll come back with another beautiful edition. Do have an amazing rest of your day.